Dear students, I have come with a new module, Discharge of Contract. So the performance of contract will come to an end when they will complete the contract. That is, discharge of contract meaning both the parties will complete their share of obligation. That is the discharge of contract. Now, what is the meaning of discharge of contract? First thing you have to remember, termination of the contractual relationship between the parties. An agreement or a contract entered to supply raw material to a person from Bangalore to Chennai. So they entered into contract. Then when the materials are supplied and the payment is received, the contract has come to an end. So the mode of discharge of contract you have to remember. Mode of discharge, how the contract can be discharged. What are the different ways in which contract can be discharged. Sometimes everything will go smoothly. Sometimes it may not be. So what are the things, what are the ways of discharging the contract? That is what we are going to see in this module. Now, mode of discharge of contract, 5 points are there. First is by agreement or consent. Second is by impossibility. Third, by lapse of time. Fourth, by operation of law. Fifth, by breach of contract. Now, first one, by a discharge by agreement or consent. This is subdivided into 6 points. One is novation, alteration, rescission, remission, then waiver, merger. So let us see these points one by one in detail. Now, what is novation? Novation, when parties to a contract agree to substitute the existing contract, that is called novation. See, for example, before COVID, you entered into a contract. After COVID, so many things happened. So it was for the construction of the building. So before COVID, whatever they agreed, it has come to a standstill all of a sudden. So after COVID, when they resume the work, there will be a lot of changes. So they want to change the contract. So novation, that is by substituting a new agreement, new contract. So before COVID, this agreement was, or the contract which was signed, now they are changing after the COVID. That can be called a novation. So novation can happen in 2 ways. One is involving change of parties or involving substitution of a new contract. If there is, imagine that person entered into contract has died due to COVID. So either his legal representatives will decide whether they are going ahead with the contract or they are giving it to a new person. Or substitution of a new contract. After COVID, the terms and conditions changed. So they are entering into a new contract altogether. Now, what are the change of parties? So how they can bring a new contract by change of parties? One party to the contract is substituted by another person. 2 contractors were there. One contractor died. So the existing contractor is continuing. Or another contractor they are bringing into the contract. Now original contract remains the same. Only the persons are changed. The person so substituted need not perform the contract. So here you have to remember original contract A and B. So now A has indebted money to B. So now A is telling that instead of me, C will make the payment. That meaning A need not make the payment now. With this contract will become between B and C. So that is the person substituted will perform the contract. That you have to remember. Mutual consent is a must in this case. So here the debt between A and B. Now they are saying that what they are saying that C will instead of A, C is going to make the repayment. So C is going to perform the contract. So the person substituted, that is C, C will perform the contract. But to make this contract between A, B and C as a new contract, we have to remember that mutual consent is a must. So I have explained again, Anil owes money to B under the contract. They agreed that in future, C will clear the debt instead of B. So here, person is changed and that it will become a new contract. Now, substitution of a new agreement. So this is another possibility for novation. When you are changing the agreement, a new contract is entered into by the parties. So by the same parties, so this, by one example if you will give, it was a debt. So after COVID, they were not able to repay that. So their house property, they are giving it as a mortgage instead of the debt. So the debt is becoming a mortgage. Parties are same. Bank will be involved and the party who took the loan will be there. But the change or the pattern of the contract is changed. So that is the contract is changed by substitution of a new agreement. Now, essential conditions for novation. Original contract must be subsisting and unbroken. The original contract is in place. Second is consent of all the parties is required. All the parties to the contract must agree. If one person will show the disagreement, then it is not possible because it is changing. That binding, legal binding will be there, whoever involved in the contract. Now, novation should occur before the breach of the contract. Before the breach of the contract, that is very important. After the breach of contract, legal consequences will be different. So, before the breach of contract, that novation has to happen. Parties should agree and they have to come with whether they are changing the parties or they are coming with a new agreement. Now, a new contract should be enforceable. That should be a valid contract which is valid, fulfilling all the 10 essential elements of a valid contract, and that can be enforced in a court of law. Now, second thing is by alteration. How a contract can be changed by alteration. Changing one or more material terms of a contract. So, that meaning the original contract is discharged. See, for example, I want to buy a car. So, first I entered into a contract for a specific model. But later I have seen in the social media that there are some complaints about that. Companies recalling that vehicle. So that same company I am asking for another model. So that is the one or more material contracts. The company, car company remains the same. So I am deciding another model of that company, car company I am selecting. So the material terms are changed. Original contract is changed and material alteration by one of the parties without the consent of the order will make the contract void. If I want to change the model of the car from the my earlier contract, so my consent is important and the car company's consent is also important. If the consent is not between the car company and or the car dealer, automobile dealer and myself, then the contract will become void. Now, what is the difference between novation versus alteration? Parties to the contract. In the case of novation, maybe change of parties. You can bring another party to the picture. Whereas alteration, parties remain the same, only the terms of the contracts are altered. So this is very important. In the case of novation, parties can be changed. A new person can be brought into the contract. Whereas in the case of alteration, parties remain same, but the terms of the contract will be changed. Now, what is rescission? Rescission meaning cancellation of the contract. Cancellation must be done before the due date by mutual consent. Same parties may impliedly rescind. Sometimes parties may impliedly rescind the contract. So they remain silent about their promises without complaining about non-performance. Cancellation of the contract. Rescission meaning it's cancelling the contract. So you have to remember that. See, for example, before the due date or by mutual consent. See, for example, I entered into a contract with a publisher for publishing a book. So before COVID it happened. So after COVID, I am approaching them. So COVID time, nobody has published the books. All the economic activities has come to a standstill. It was a different mode of teaching altogether. So after COVID, what I approached them, already the agreement is signed. So here, they are not taking any action to print that. So that meaning the publisher is keeping quiet. So I asked about their silence. So then they are telling that we are not doing that. So that is rescission. They cancel the contract. They have no guarantee whether they will be able to sell the books. So that is the cancellation of the contract by mutual consent. But mutual consent is required. Then I also should agree for that. So that is very important. Mutual consent of the parties is required for rescission. If my consent is not there, I can pay for compensation. I can ask for compensation because they wasted my time thinking that they will publish the book. Fourth is remission. Now, acceptance of a lesser sum than what was contracted for or a lesser fulfillment of the promise made. See, for example, somebody has to give me 1 lakh rupees, borrowed 1 lakh rupees, but he lost the job. He met with an accident. He is hospitalized. He is no more able to work. So, based on the condition, situation, I am saying that instead of 1 lakh, give me 50,000. My opinion is that at least 50% I can recollect instead of not fully giving up the 1 lakh. So consideration is not required for remission. This is out of the situation I am making this decision. Next is waiver. Waiver is deliberate abandonment or giving up of a right. The party getting this option is relieved from the obligation. Parties agree that they are no longer bound by the contract. Neither consideration nor an agreement is required to constitute a waiver. Abandonment of giving up a right. Earlier I was an agent for a company. So now after that COVID, I'm telling that I'm not going to do that business again. So anybody who's got a dealership, so that business is closed. So that meaning due to COVID, the business is closed. So that whoever agents and all, they have no right to claim that because everybody will understand the situation of COVID. So they are telling that they are no more there is company itself is closed, so the agency also is stopped. So the deliberate abandonment, we are not going to file a case or anything. We are giving up the right. We don't want that agency. So that is the waiver. Here you have to remember, consideration is not required. Agreement is also not required to constitute waiver. Parties are agreeing. They are no longer bound by the contract. The company, when they will inform the agents, we are no more continuing with the business. Next is merger. Merger, a person enters into a contract by which he gets certain rights, which are superior to the rights possessed earlier. The one example is tenant becoming the house owner of the property. See, for example, a person living as a tenant, then he has got the right, certain rights as a tenant. But imagine after few months or few years, they're telling that this property we are offering for sale. So he is buying that property. That meaning the tenant is becoming the owner. He is getting a superior right. Now, this is what I want to explain in this module, the methods of discharging the contract, and the first point and the subdivisions we have explained in detail. Happy learning. Thank you.